Good afternoon. Thank you for joining us today for Foley and Lardner's Web Conference 2018 PTAB A Year in Review. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can access a copy of the slides in the resource list widget available on the left-hand side of your screen. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email with it to Taylor Bannister at tbannister@foley.com. To be eligible for CLE, you will need to log in to the On24 session and answer a polling question during the program. Please note, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, or New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form with the code to Taylor Bannister at tbannister@foley.com immediately following the program. At this time, I would like to turn the presentation over to today's speakers, George Beck, George Quillen, and Chase Brill, all resident in Foley's Washington, D.C. office. Thank you.
Good afternoon. This is George Beck. I'll be one of the presenters today along with my colleagues Chase and George. And this is Chase Brill. I am currently Senior Counsel in Foley's Mechanical and Electromechanical Technologies Practice Group, also a member of our Patent Office Trials Group. My practice is focused on patent counseling and prosecution, but I've also worked on about 24 or so inter-parties reexaminations and inter-parties review proceedings. So that's a significant portion of my practice, and I'm very happy to have this opportunity to speak with you today.
I'm George Quillen, Chair of Foley & Lardner's PTAB Trials Group. I was also one of the counsel for Greene's Energy at the Supreme Court. With my colleagues, George Beck and Chase, on slide 4, you'll see that we're going to cover highlights of a dozen or so PTAB topics from the last year. Starting with 2018 statistics, we'll proceed to Supreme Court cases and then sovereign immunity. Next, we'll cover real party and interest, as well as amendments in AIA proceedings and changes in the claim construction standard. Then we'll review updates to the trial practice guide and changes to the SOPs, finishing off with a look at implications and trends and a look forward at a few cases to watch in the coming year. Next slide. So first, let's look briefly at some 2018 trends and statistics based mostly on the PTO's own data, which runs through November of 2018. On slide 6, you'll see the petitions filed by month, and you'll note a significant uptick in filings in November of 2018, which might be caused by petitioners wanting to file before the effective date of the change in the claim construction standard. Slide 7 shows the percentage of filings by type. The pie chart reflecting all filings since 2012, and the bar chart showing the last 3 years. The 2018 data, as you'll see, is very consistent with the cumulative data. Next, on slide 8, you'll see a comparison of new patent cases filed in 3 forums: the District Court, the PTAB, and the ITC over the past decade, both in absolute numbers and as a percentage. One trend to note is that since 2015, the PTAB's percentage share of new cases has been steadily growing. Finally, on slide 9, you'll see PTAB institution rates. The long-term trend has been a decrease in the institution rate. The uptick for fiscal year 2019 is based, of course, on just 2 months' worth of data, so it remains to be seen whether that uptick will continue or whether the institution rate will plateau or continue to decrease. We'll just have to wait and see. Moving on then to slide 10, our next topic will address the Supreme Court's IPR decisions, SAS Institute against Iancu and oil states. On slide 11, first is the most significant IPR decision of the year, oil states against Greene's Energy. For disclosure, again, Foley and Lardner represented Greene's Energy Group. It's the most significant, not because there were 58, count them, 58 amicus briefs, although there were, but because had the decision gone the other way, there wouldn't be any IPRs anymore. Instead, the Supreme Court, by a 7-2 vote, upheld the constitutionality of IPRs. No violation of Article 3, and consequently, no violation of a 7th Amendment right to a jury trial. Granting a patent, says the court, is granting a public franchise, and IPRs fall squarely within the public rights doctrine. The court emphasized the narrowness of its holding, listing several issues that it was not deciding, one of which we'll touch on at the end today in our cases to watch topic. And the court noted that its decision shouldn't be misconstrued as suggesting that patents aren't property for purposes of the Due Process Clause or the Takings Clause. On slide 12, we have the next Supreme Court case, SAS against Iancu, which wrought the biggest change in PTAB institution practice. The court held that it was error for the board to partially institute an IPR on only some of the challenged claims. Instead, ruled the court, the statute required a binary choice. If the PTAB chose to institute, it must do so on all challenged claims. The court observed that the statute suggests a regime where a reasonable prospect of success on a single claim justifies review of them all. And beyond institution, the statute confirms that the petitioner's petition, not the director's discretion, should guide the life of the litigation. The Federal Circuit has extended the SAS all claims holding to apply to all grounds. That's PGS Geophysical against Iancu, saying, quote, equal treatment of claims and grounds for institution purposes has pervasive support in SAS, close quote. And of course, the PTAB has issued its own guidelines on how it's going to implement that. Slide 13 addresses some of the post-SAS Federal Circuit decisions dealing with partial institution and remands to the PTAB. You can see how that came up in different contexts. Patent owners requesting, petitioners requesting, both parties jointly requesting, and it came about at different stages of the litigation and appeal. On slide 14, as you can appreciate, in addition to its effects on PTAB practice, SAS also had an effect in the district courts, especially regarding obtaining a stay of the litigation. And in slide 15, we offer examples of district court decisions to stay at different chronological points. You can review those at your leisure. Turning back to the PTAB on slide 16, the SAS decision may be affecting the thoroughness of board institution decisions. One study early on estimated that half of the decisions instituting trial did not analyze all the claims and grounds. For the scholars in the audience, this topic might be a fruitful area of research going forward. But for us, for now, let's turn to slide 17 and a topic that garnered a great deal of attention at the time: sovereign immunity for American Indian tribes. So the question is, if an Indian tribe becomes the owner of a patent, does the tribe's status as a sovereign shield it from being drawn into an IPR? On slide 18, the Federal Circuit says no. This is St. Regis Mohawk against Allergan. The Federal Circuit says no, immunity does not apply for several reasons. First, in the Federal Circuit's view, in this context, an IPR is akin to an agency enforcement action, where an agency chooses whether to institute a proceeding based on information supplied by a private party. A second factor is the role of an IPR. In the court's view, it's an act by the agency in reconsidering its own grant of a public franchise. A third factor is that PTAB procedures in an IPR don't mirror the federal rules of civil procedure. And an IPR hearing, says the court, is nothing like a district court patent trial. Finally, says the court, there's no dispute that sovereign immunity would not apply in an ex parte or inter partes re-examination, and the Supreme Court has recognized that an IPR has the same basic purpose as a re-examination, that is, to re-examine, to re-evaluate an agency decision. So the upshot of all that is no tribal immunity in an IPR. The court recognizing but specifically not deciding whether a similar analysis would apply to a state's sovereign immunity argument. So that wraps up the first few topics, and we'll turn next to George Beck.
Thank you, George. I'm going to now turn to some issues regarding the real party and interest standard. As we can recall, the real party and interest standard is a statutory requirement. The requirement's significant because it may be a basis to deny a petition where an unnamed real party and interest is subject to the statutory bar under Section 315B.
It should be noted, not to overstate the importance of RPI, but it can matter quite a bit in certain proceedings. But as a general matter, a failure to name all real parties in interest in a petition is not always fatal. The PTAB has made it clear that a mistake in identifying a real party in interest will not necessarily bar the IPR. It has allowed correction by filing an updated mandatory notice and indicated that the updated mandatory notice generally will not change the filing date of the petition. So adding an additional real party in interest that is not time barred as of the filing date of the petition will not necessarily result in a bar. Nevertheless, it's important for petitioners to make every effort to identify all the necessary real parties in interest, and if there's some question, at least identify the parties that might be affected by the proceeding so that the board can consider issues such as potential conflicts of interest. But what I'm going to focus on are the cases where there was a significant issue about an unnamed party that arguably should have been named as the real party in interest, such that if that party was added in, there would be a time bar to the petition. The first case that I wanted to discuss is the Wi-Fi 1 versus Broadcom case. Prior to this decision, the Federal Circuit had held that the determination under 315B was final and non-appealable under Section 314B. In Wi-Fi 1, the Federal Circuit reconsidered its prior decision en banc and held that the PTAB's determination under Section 315B is subject to appellate review. So this opens the door to review of PTAB determinations on this issue. The court indicated that the prohibition on judicial review in 314D addressed the PTAB's authority under 314A, that is, the merits determination as to whether there's a likelihood that at least one claim would be found unpatentable. Previously, again, the court had taken the view that the appellate jurisdiction did not extend to the time bar determinations under 315B. Going forward now, though, we can expect further review of that determination by the board. The first of such a case was applications in Internet Time versus RPX. So here the court considered whether the PTAB relied on an erroneous understanding of real party and interest in determining that the RPX's IPR petitions were not time barred under 315B. Here the Federal Circuit found that, or held that the PTAB's determination was incorrect. The decision is interesting in several respects. First, while the decision criticized the board's application of the real party and interest standard, it generally agreed with the statement of the requirement set forth in the trial practice guide. You may recall that the trial practice guide provides an overview of the RPI standard and refers to the factors set forth by the Supreme Court in the Taylor case. The Federal Circuit's principal criticism of the board in AIT centered on its application of that test. For example, the decision found the PTAB failed to give adequate weight to Salesforce's relationship with RPX and the nature of RPX as an entity. And I won't go through the specific facts of the case, but RPX is a particular type of entity that assists companies in defense of IP claims, and the factual issues were relatively complicated. It really focused on RPX's relationship with Salesforce. Significantly, the decision emphasized that the test for real party and interest is very fact-specific. It stated that it requires a flexible approach with an eye toward determining whether the non-party is a clear beneficiary of the proceeding that has a pre-existing established relationship with the party. Now, this is important and because in many cases the PTAB focuses very heavily on whether an unnamed party exercised control over the IPR. So factors such as paying for the IPR, commenting on draft petitions, things like that are indicia of control. I think many people recognize that as maybe the most important factor. The court in AIT noted that there were facts suggesting that Salesforce did exercise some control over RPX, but the PTAB focused as to that factor on just a declaration by RPX saying that there was no control. The important thing I think about AIT is that the court really emphasized that there has to be weight given to other factors, particularly the pre-existing relationship between the petitioner and the unnamed party. And in that regard, the court cited with approval the approach taken by the PTAB in the Cisco case. In that case, the PTAB indicated that the relationship between the parties may indicate that the petitioner was actually acting as a proxy for the unnamed party. Now, following AIT, the Federal Circuit again reviewed a board's determination in the Worlds v. Bungie case. In this case, the focus really focused its analysis on the allocation of the burden of persuasion between the petitioner and the patent owners. So this case gives some guidance as to how the issue is to be considered as a procedural matter by the board. The court clarified that the petitioner carries the burden of persuasion to demonstrate that the petition is not time-barred. The board can accept the petitioner's initial identification of the RPI in the petition, but if the patent owner produces evidence showing that a particular third party should be named, the board really needs to consider it. Here, the Federal Circuit indicated that the board's decision was incorrect because it appeared to continue to rely on the petitioner's initial identification of the real party in interest, and based on some language in the board's decision, indicated that it looked like the board may have shifted the burden of persuasion to the patent owner. Based on that, the court remanded back to the PTAB to reconsider the issue. Now, the decision does not define how strong the patent owner's evidence needs to be to call into question the petitioner's identification of the RPI, but it does seem like it would be something less than a preponderance. I think the important thing, though, is there has to be some type of evidence. It can't just be a conclusory allegation. So in summary, as to the real party and interest issues, I think we can expect more appeals directed to the 315B time bar. We expect that one focus of future cases will be the extent that pre-existing relationships between the parties will be viewed as establishing that there should be another RPI. And this obviously leads to a lot of fact-intensive issues dealing with whether the petitioner has an indemnification obligation, how much of a relationship there is as to products at issue in a particular court proceeding. None of those factors alone are probably dispositive, except perhaps control, but it'll be important for the board to actually vet those issues once they're properly identified and raised by a patent owner. And I think one consequence of that will be that the board may be more willing to grant discovery as to that issue, again assuming that the patent owner adequately calls into question the issue and shows that it's a significant one. I'd now like to turn to another issue, and that's the effect of the Aqua products decision on amendment practice in AIA adversarial proceedings. As many of us will recall, one very significant decision from 2017 was the Aqua products decision. In that case, the Federal Circuit examined which which party bears the burden of persuasion as to amended claims. The prior practice of the board was to allocate that burden to the patent owner as movement in a motion to amend. Now, the Federal Circuit reviewed that issue en banc and was very splintered in terms of the underlying analysis. However, it did hold that, at least under current practice, the PTAB may not place the burden of persuasion on the patent owner. However, significantly, it did leave open the possibility that the PTAB could allocate the burden of persuasion by adopting a new rule to that effect. And as I'll discuss shortly, that is something that seems to be under consideration by the board. Now, following Aqua products, the board issued a memorandum that basically restated the narrow holding of Aqua products as to the burden of persuasion. In that initial guidance, there really was not any major changes procedurally in how the board would handle a motion to amend going forward. And more recently, the board amended the trial practice guide and clarified that the petitioner can file a 12-page surreply, which I think is it makes sense given the fact that the petitioner is bearing the ultimate burden of persuasion. Most recently, in last October, the PTO requested comments on whether it should continue to allocate the burden of persuasion on the petitioner based on its preceding practice, the practice prior to the Aqua products decision. So what effect has Aqua products had on motion to amend practice overall? So as shown in slide 25, we can see that there was a significant increase in motions to amend subsequent to the Aqua products decision. The PTO has noted that the number of motions to amend filed through the first half of fiscal year 2018 exceeded the number of motions to amend filed for the entire fiscal year 2017. So just adding up what was shown on this slide, just from the first half, there was 54 motions to amend in fiscal year 2018 versus a total of 50 in 2017. And in 2016, it was about the same number as 2017, it was 56. So it does seem clear that patent owners, at least, see Aqua products as increasing the likelihood of success in pursuing a motion to amend. However, at least based on some studies, it does seem like the actual outcomes, substantive outcomes, have not significantly changed. In slide 26, we refer to one study that found between October 2017 and March 2018, over 90% of the motions to amend were denied. The grounds for the denials were about a third were lack of written description support, half of them for prior art reasons, and about 14% for some combination of the two. And I think the remainder were really just substantive or procedural issues. So even with the burden being shifted to petitioner, it's still difficult to succeed with a motion to amend. I think the take-homes for that are unchanged. It's important for the patent owner to address written description and patentability, and not to hold back and wait for a reply. Now I'm going to change to a related topic, which is the PTO's proposal to facilitate amendments in AIA proceedings. So in this last October, the PTO published a proposal for implementing a new procedure, and it requested comments. The comment period extended through initially through December 14th, but then they extended it to December 21st. So currently, a patent owner only has a right to move to amend once following institution. That is, as a matter of right. It can file a second motion where there's good cause shown, but that, for practical purposes, is very difficult. The motion amend under the current practice usually occurs at the time the patent owner files its response. So the new proposal would have a different process, and it would permit the patent owner to file a motion to amend much earlier, within 6 weeks of institution. The petitioner would then get 6 weeks to file an opposition, and then within 1 month of the petitioner's opposition, the board would issue a preliminary non-binding decision on the motion. If the preliminary decision is unfavorable as to at least one proposed substitute claim, the patent owner could file a reply and the petitioner could file a surreply. Now that's in the case of an unfavorable decision. Again, in such a case, the patent owner would be allowed the option to revise the motion to amend and even propose new substitute claims. And that would be considered good cause under the existing rule. In the case of a revision to the motion to amend, the petitioner could file an opposition, the patent owner would then reply, and the petitioner file a surreply. Now, if the preliminary decision is favorable as to all amendments under this proposal, the petitioner can file a reply, and the patent owner can then file a surreply. So the take-home here is that there's an earlier submission with an opportunity to revise the motion to amend. The Patent Office has published, as part of its request for comments, the timeline that we've reproduced here in slide 29. We have not included it in the slide deck, but the PTO also published as Appendix A2 to its request for comments an overlay of this procedure against the current timeline. Now, in that overlay, the petitioner's opposition to the motion to amend would be due at the same time as the patent owner's response, and the petitioner's surreply or opposition to a revised motion would be due at the same time as the petitioner's reply. So how will this proposal work? When will it go into effect? What's its potential impact? Now, it's really not entirely clear, and I think it's certainly subject to revision by the PTO after considering comments. The PTO has indicated this would be a pilot program, and if implemented, it could go in effect very quickly because it would not require formal rulemaking. It's also unclear if both sides wish to opt out, whether the PTO would grant that, but as a pilot program, it would not necessarily be applicable to all pending proceedings. Now, as to how quickly it'll go into effect, as I said, because there's not a requirement for rulemaking, the PTO could start it very soon, and I think they indicated that it might extend for a year, and it could be extended with notice from the PTO. So the real question then is what impact would this procedure have to participants in the program, and if it's adopted wholesale? Again, I think the impact is really unclear, but it depends in the detail. At a minimum, though, it does seem like it would result in an increased cost to the parties just by virtue of the fact that there'd be at least one additional round of briefing on the motion. And it would also seem to impose a potential burden on the board itself, because it would be issuing this preliminary non-binding decision. On the other hand, the proposed changes do appear to be directed to ensuring that both the patent owner and the petitioner are fully informed of the procedural and substantive requirements and have an opportunity to respond to issues raised in the preliminary decision. So at least in my view, it seems like the board's really taken an active approach to ensure that the merits of the motion to amend are being assessed in sufficient time and there's sufficient guidance given to all the parties. But I think the impact will depend in part on the implementation in light of the public's comments. Now, I'd now like to turn to the changes in the claim construction standard used in AIA trial proceedings. So the prior rule for the applicable standard of construction was the broadest reasonable, required the broadest reasonable interpretation, or the BRI standard, at least as to claims that remained in force throughout the proceeding. The PTO only applied the district court Phillips standard for proceedings in which the patent at issue had expired or would shortly expire after institution. But following notice and comment, the PTO revised Rule 42-100B effective last November, and it clarified that it will apply the Phillips standard, which focuses on the ordinary and customary meaning. One notable aspect of the rule change is that it does not just apply to the patents that the issued granted patent claims, but it also would apply to substitute claims presented in a motion to amend. So what impact does this change have or will have going forward? While I think it is subject to debate, most commentators seem to believe that the change will not have a dramatic impact on the merits. While there are a handful of cases that suggest a different result stemming from application of BRI versus the Phillips standard, as a general matter in practice, the PTAB considers the same evidence relevant to claim construction as if presented by the parties as does the district court. And it does seem to be, at least the consensus is, that it's a very rare occurrence where those different standards lead to a different outcome. That being said, as George Quillen noted, there was a spike in filings prior to the change in the standard, so at least some petitioners seem to think that the change is meaningful. At least in my view, I think the practical impact of the change is that it'll prevent parties from trying to justify different claim construction positions in the PTAB and in district court. I think most people would agree it probably never has been a good idea to present conflicting positions, but obviously there's an incentive for petitioners to advocate for a broader claim construction at the PTAB than it might in district court. So the change may serve to eliminate that temptation. I will now turn the presentation over to Chase Brill.
Thanks, George. So one additional change in 2018 was that the board published updates to the trial practice guide, and these are the most major updates that have been made since the trial practice guide came out in 2012. And these updates are prepared directly by the board, so they give some insight into what the board is thinking, and those insights are particularly interesting given the increased burden on the board caused by the SAS decision that George explained earlier. And what we see is, maybe unsurprisingly, the board is concerned with increasing efficiency and ensuring it's able to meet its statutory one-year deadline between the institution decision and the final written decision. Now, the first update to the trial practice guide relates to expert testimony. It lays out when expert testimony is appropriate, and there are no real surprises there. You can properly use expert testimony to provide background, to explain prior art, and to explain motivation to combine. But one interesting statement in the updates is that because an inter-parties review can only be requested on the basis of prior art consisting of patents in printed publications, Section under 311B, expert testimony cannot take the place of disclosures from patents or printed publications. In other words, expert testimony may explain patents and printed publications, but it's not a substitute for the disclosure in a prior art reference itself. Now, you might ask, well, what does this have to do with increasing efficiency? Well, during a webinar a couple months ago, one of the PTAB judges pointed out that the reason for this clarification is that the board has been spending substantial time on issues relating to expert testimony. For example, parties are often filing motions to exclude certain portions of expert declarations or expert testimony, and arguments over those issues are taking up board resources that it would prefer to spend on other issues. So the board is trying to provide clear guidance on the type of expert testimony that's appropriate to reduce those kinds of disputes. The problem, though, is that the expert testimony guidelines in the updates to the trial practice guide seem to be a little inconsistent with KSR, which says the obviousness analysis can't be confined by overemphasis on the importance of published articles and the explicit contents of issued patents. And it's certainly inconsistent with the MPEP, which says the prior art is not just limited to the references being applied, but also includes the understanding of a person of ordinary skill in the art. The updates justify this. The updates to the trial practice guide justify this by pointing to Section 311B, which limits prior art considered to patents and printed publications. But it's generally accepted that was intended to avoid the need for the board to look at things like offers for like sales and offers for sales and things like that are very difficult to prove in a short amount of time. It's not so clear that limitation was intended to avoid the use of expert testimony on the knowledge of a person of ordinary skill in the art. So it almost seems that while the PTO is trying to increase consistency between AIA proceedings and district court proceedings in other areas, for example, in the claim construction standard that George just talked about, this seems to do the opposite, and it leaves open the possibility that petitioners who lose in an AIA proceeding might argue in district court that they shouldn't be stopped from relitigating invalidity because the board wouldn't consider expert testimony about the knowledge of a person of ordinary skill in the art. So this is something important to be aware of when preparing expert declarations and preparing experts for their oral testimony. The trial practice guide also, the updates address considerations that go into whether to institute an inter-parties review. Now, notably, there's no statute that expressly compels the board to institute a proceeding. Instead, the applicable statute, Section 314A, is written in the negative, so it only states the conditions where the director may not authorize an IPR. The updated trial practice guide embraces the board's ability to deny institution, likely because the board recognizes it needs to limit its caseload given the SAS decision. So the trial practice guide updates lay out two sets of considerations that will be taken into account when making institution decisions. The first set are the Becton-Dickinson factors, which apply to all new petitions. And the second are the general plastic factors, which apply to follow-on petitions only, where the same patent has been previously challenged in an AIA proceeding. I'll quickly go through both of those. So on slide 37, we showed the Becton-Dickinson factors. They focus on whether the prior art cited in the petition was previously considered during examination, the extent of overlap between arguments made in the petition and those made during original examination, and whether there's new evidence warranting reconsideration of the same prior art. Now, these are all factors that the board has been considering since the IA proceedings first started, but now they're all laid out clearly. So parties are aware of what's going to go into these determinations. Now, on this next slide are the general plastics factors for follow-on petitions. There are some additional considerations here beyond whether prior art has been previously considered. The first is whether the same petitioner filed the follow-on petition as the initial petition, which makes institution less likely. The second is whether the prior art used in the follow-on petition was found after the first petition was filed, which makes institution more likely. The third is whether the petitioner has already received the patent owner's response in the first petition at the time of filing the second petition. So in that case, the board is less likely to institute on the second decision, and the board is just trying to avoid gamesmanship. The board doesn't want a petitioner to see all the patent owner's arguments and then draft a second petition based on those arguments. The fourth and fifth factors here relate to the length of time between petitions and the length of time between the petitioners when the petitioner learned of a prior art reference and the actual filing of the second petition. If there's if there's a long delay between those times and there's no reasonable excuse for that delay, institution will be less likely in the follow-on petition. And then finally, the sixth and seventh factors are the broadest. These allow the board to consider its finite resources and the one-year requirement for a final written decision. So as a general matter, the board's practice has already been to take a harder look at follow-on petitions, but it seems likely that it will be even harder to get those petitions instituted going forward. So in addition to the updated trial practice guide, PTO also issued some helpful revisions in the standard operating procedures. And on slide 40, this talks about SOP 1, which relates to assignment and reassignment of board panels. So with respect to initial APJ assignments, it sets forth four main factors, which are, in order of importance, avoiding conflicts of interest, the preference for an APJ for ex parte appeals versus other cases, maintenance of workflow and workload, and assigning cases to APJs with a relevant technical background. Now, the board has already done generally a good job on assigning cases appropriately, but this just lays out more clearly how those assignment decisions are made. And then additionally, going forward, the board will provide some more transparency regarding the reasons for panel changes. So whenever there's a panel change, the board is now going to inform the parties of the reason for that change, which could be, for example, recusal due to a conflict or unavailability of an APJ or a need to meet PTAB deadlines. The second SOP is more interesting. It creates a new precedential opinion panel, or POP, for important rehearings. Now that POP is going to have three default members: the director, the commissioner, and the chief judge, and then several possible additional delegates: the deputy director, the deputy chief judge, and an operational vice chief judge. These POP panels can be convened at the director's initiative, or by a party's request, or pursuant to request by another member of the board. And on the next slide, we show the types of cases that the POP is intended to hear, which include constitutional questions, important issues regarding statutes, rules, and regs, important issues regarding binding or precedential case law, issues of broad applicability to the board, and resolution of conflicts between board decisions. Now, if the POP review is requested by a party, that party has to make a statement certifying that the board panel decision at issue meets one of these requirements, essentially. So the party has to assert that the decision, they believe the decision was contrary to a Supreme Court, CAFC or board decision, or to a constitutional provision or statute or reg, or that the case requires an answer to a precedent-setting question of quote-unquote exceptional importance. Now, the USPTO expects that this POP will replace the prior practice of using expanded panels with this new practice, which is more transparent and predictable. And the USPTO also predicts that more opinions will now be designated as precedential. So it's going to be important that practitioners keep up to date by reviewing all those precedential opinions that will be provided by the POP, because they often include helpful practical guidance that isn't found elsewhere in the rules and regs. Okay, so we've now gone through what we think is the most relevant developments in 2018. So what does it all mean? Well, as a general matter, petitioners continue to encounter stronger headwinds, particularly at the institution stage, and especially for follow-on petitions. Now, of course, this has kind of been true every year since we started getting institution decisions in 2013. The petitioners have encountered lower and lower institution rates. I mean, the good news for petitioners is that the institution rate finally seems to be leveling off at right around 60%. And the reduction in the institution rate hasn't seemed to significantly impact the popularity of AIA proceedings. I mean, yes, the overall number of petitions filed has decreased in 2018, but the relative percentage, as George mentioned earlier, of the relative percentage of total patent cases that are being filed as AIA proceedings continues to increase, as it has since 2015. Now, one of the biggest changes this year results from the SAS decision, and one important thing to remember when drafting petitions is that if trials instituted and final written decision issues, estoppel is going to apply to all the challenge claims and all the grounds of petition in the petition. So there's no longer non-instituted grounds. As a general matter, it's never really been a good idea to challenge claims in an AIA proceeding if the prior art's weak. But at least before the SAS decision, if the board did not institute on some claims, the petitioner wouldn't be estopped from challenging those claims in district court. But now that estoppel applies to all the challenge claims, it's going to be even more critical that claims only be challenged where the prior art is strong. Additionally, we found that at the final written decision, the board appears to be giving less deference to the initial institution decision. Now that might not be surprising because now, after the SAS decision, not all grounds are even being addressed in the institution decision. The burden for doing so would just be, astronomical. So now, just because a ground was adopted in the institution decision, it doesn't mean it's going to be maintained in the final written decision, and vice versa. That said, the overall claim cancellation rates are still high, and at least at the moment, motions to amend are no easier than they were prior to Aqua products. So while patent owners may have some additional negotiating power now prior to institution, and due to decreasing institution rates, petitioners still have the upper hand after institution. Now I think we're going to stop for a moment to provide some CLE information. Taylor, do you have that?
Yes, thank you. At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question on the screen after it is announced and press the Submit button. The code is B6BMW. B as in boy, 6 as in the number 6, B as in boy, M as in Michael, W as in William. Again, that is B6BMW. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget on the left-hand side of your screen. As a reminder, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. Again, one more time, the code is B6BMW. At this time, the poll is now closed, and I would like to turn the program over to our speakers. Thank you.
Great. Thanks very much, Taylor. Appreciate it. We don't have much time left, but we do want to finish up with the cases to watch in 2019 because there's likely to be some doozies. And the first set relate to AIA standing issues. The first case is return mail versus U.S. Postal Service. That case is going to address whether the U.S. government has standing to file petitions seeking to invalidate patents under the AIA. So in this case, the U.S. Postal Service successfully petitioned the PTAB to invalidate return mail's patent on a system of handling undeliverable mail in a CBM review. Return mail is arguing that the applicable statute says a person may file an AIA petition, and that the term person has a specific legal meaning that excludes the government. Cert has already been granted in this case, so it will be heard in 2019. It's possible the Supreme Court will limit its decision to just CBM reviews because the language in the CBM statute is different from that in the IPR statute. But the word person is used in the IPR statute, so it's also possible the decision could have broader implications. So we'll get a decision in this one sometime this year. Additionally, cert has been requested in 2 other cases involving standing, RPX and JTEC. Now, as George mentioned earlier with respect to the RPI issues, RPX is a patent risk management service provider. So it challenges patents on behalf of its paying customers. But RPX itself doesn't really have any infringement liability. They're not performing infringing activities. JTEC does not sell infringing products, but it argued that it's developing a product that could be at risk of infringing the patent at issue. In both these cases, RPX and JTEC make basically the same argument, which is that, according to the AIA, a party to an inter-parties review or post-grant review who's dissatisfied with the final written decision of the PTAB may appeal the board's decision only to the CAFC. And they argue that because of that particular statute, the traditional standing rules should not apply. Now, cert hasn't been accepted yet in this case, but this question comes up frequently in AIA proceedings, and it seems fairly likely the Supreme Court will take these cases on. And finally, it seems very possible that we'll see another case this year relating to the constitutionality of AIA proceedings. And George mentioned earlier, the oil states case left open the possibility of a constitutional challenge against AIA review of patents issued before the AIA was passed. So what the Supreme Court said in the oil states decision was that oil states does not challenge the retroactive application of inter-parties review, even though that procedure was not in place when its patent issued, nor has it raised a due process challenge. Well, in several cases before the Federal Circuit, patent owners have argued that because they didn't know when they filed their applications that their patents could be subject to AIA review, application of the AIA to their patents violates due process. Now, there's no specific cases in which cert has been requested yet, but it seems very likely this will happen sometime this year, so stay tuned. And with that, I think we will take any questions that we've received. And it looks like we have no questions, and at least it's well, as far as I can tell. Sorry, go ahead.
I did see there is one question or a comment that as to the board's treatment of expert testimony as clarified recently, that the limitation would be in the institution phase, but not necessarily in the merits phase in the final written decision. So the comment is that the potential conflict with KSR may not be so pronounced or problematic if it's not applied. The limitations on expert testimony is not applied at the written decision stage.
I see that now.
Thank you for that comment.
Yeah, and I think my response to that would be, in general, it's extremely hard to add new types of arguments or new evidence after the institutions phase. Even though you can file a follow-on declaration as the petitioner with your reply, you're still limited to the issues that you initially raised in your petition or things that are directly responsive to what is in the patent owner response. So yes, it's possible you might be able to use expert testimony in a broader manner after institution, but as a practical matter, it's been difficult.
Seeing no other questions, and I think we're past the hour. Again, we'd like to thank all the participants today. If anyone has any follow-up questions, feel free to reach out to contact any of the speakers. Thank you very much.